May it please the court and opposing counsel, my name is Yolanda Wilson and I represent the plaintiffs Joyce and Voigt, who were awarded default damages against PepsiCo when PepsiCo failed to appear in court. PepsiCo's counsel, Mr. Reneker, now he just told you that the reason that they did not appear in court is because the secretary that signed for the paperwork when she was served, she just blew it off. And Mr. Reneker failed to mention in actuality that there were two secretaries who just blew it off in two different offices. Their excuse was that the summons got lost in piles of paperwork, or they had an important meeting to work on. Now, the only issue here before you is whether PepsiCo's failure to respond by blowing it off in two different departments is excusable based on statutes and precedent. This is what we do know. Office staff signed for paperwork at their corporate headquarters, the center of their administrative and financial departments, so filed properly under 60B4. Corporate citizenship is based on the principal place of business. PepsiCo staff claims that they were served, but they didn't look at the papers. Now, who wouldn't look at the papers after being served? It seems very convenient that they misplaced them but found them a week after the court date. A change of venue request has not been filed by PepsiCo, so also apparently they've just blown that off too. PepsiCo's legal team has failed to mention previous cases that have found that not showing up to court for merely misplacing paperwork, it's not excusable. In Rogers v. Hartford per Life and Accident Insurance Company, when the failure of an overnight carrier to deliver a package containing a summons from the registered agent to the defendant was not excusable because the agent had telephoned the defendant to advise of the receipt of the lawsuit. Now, based on that Hartford case, PepsiCo's motion should not be awarded since they received the summons, but they also failed to establish minimal internal procedural safeguards. In Allemande Boat Company v. Kirk, the court found that gross carelessness is not considered an adequate excuse. PepsiCo should not be treated any differently than others that don't respond to their court orders because they merely blow them off. For these reasons, we hold that the district court should not risk abusing their discretion and refuse to grant PepsiCo relief from their default damages under Rule 60B. Thank you for your time and your consideration.